Running a practice can be scary. Thanks to Therapy Note's streamlined platform and legendary customer support, it doesn't have to be. Combining billing, scheduling, telehealth, e-prescribe, and more into one easy-to-use platform, it's no wonder they're the number one choice for mental health professionals everywhere. Try it for 2 months free today using promo code MODERN. This episode is also brought to you by Buying Time. Since 2007, Buying Time has supported entrepreneurs and therapists on their admin, marketing, and bookkeeping needs, and so much more.
Check out their free Buying Time Systems Inventory Checklist to uncover hidden expenses and optimize spending in your practice at buyingtimellc.com/MTSG.
You're listening to the Modern Therapist Survival Guide, where therapists live, breathe, and practice as human beings. To support you as a whole person and a therapist, here are your hosts, Curt Widhelm and Katie Vernoy.
Welcome back, Modern Therapists. This is the Modern Therapist Survival Guide. I'm Curt Widhelm with Katie Vernoy, and this is the podcast for therapists about the things that we do in our profession, the things that we do for our clients, the things that we think that we do that are smarter than everything else. And this episode is inspired by an article that has come out somewhat recently. It's actually a reprint of an article printing. It's a re-emailing of an article that was written some years ago. This article is titled No Court for Me and is written by Richard Leslie over at CPH about therapists who try to put into their informed consent language around, hey, I'm not going to go to court. You can't make me neener, 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 or some professional version of that. So we wanted to maybe expand on this episode a little bit around some of the other things that we've seen that show up in people's informed consent. So that way it ends up feeling like it's things that protect the therapist, but in reality are just whimsical fancy that don't seem to actually be enforceable and could actually be unethical or even illegal in some cases. So before we get into the bad, Katie, just tell me a little bit about your informed consent paperwork.
I feel like my informed consent paperwork expands each time I go to a law and ethics workshop. And so I've got a social media policy saying that I'm not going to be friends with clients on social media. I've got a court policy, which our friend Nicole Stoller-Peterson has put together that seems really sound. I have the new Medicare language in there. Basically, what I try to do in my informed consent paperwork is clearly say what therapy is, how we can operate together, what the limits are, what their rights are, and how, if they needed to make a complaint, they could make a complaint, and talk through all of it, because I find that unless these are therapy veterans, they are going to just sign the paperwork and not have any idea what they signed. So for me, informed consent is the piece of paper, and it's the conversation I have in the first session or so.
And I think, like you, each time that either I attend a law and ethics workshop or I give one myself, my paperwork expands. I think my informed consent is somewhere around 8 pages now, and primarily gives warnings about the risks and benefits of therapy. Hey, you might end up with really big bad feelings, and that's part of the process of looking at really big bad feelings. And also, and most importantly, with a lot of the complaints that I end up seeing going through either the licensing boards or I end up seeing on ethics committees, is people get really, really weird about money. And so being able to define and clearly define what your fee is, what it's based on, ends up being a huge piece of what informed consent ends up being. Mine also,
as well as like the cancellation policy, right?
Cancellation.
When you're going to be charged, when you wouldn't be charged, those types of things.
Exactly. Yeah. So having good informed consent, we've got some other episodes on that. We'll link to those in our show notes over at mtsgpodcast.com. We'll put some other resources there as well. This episode is really about bad informed consents.
Well, I think the first bad informed consent is none. right?
Then that's not informed consent.
That is
but-
uninformed consent or non-consent.
So I want to point out a couple of things from the CPH article. And one of the things that Richard Leslie ends up pointing out is in making clients even sign paperwork that agrees to illegal things is kind of illegal in and of itself.
Wow. Okay. Yeah, that's a good point.
And especially when, as beginning your service with clients, forcing them to sign this paperwork before you'll even start can put them under undue stress. And then it's upon the therapist to have to defend themselves in that situation. So here's really kind of the big warning where don't have stupid stuff in your informed consent and
Or illegal stuff or unethical stuff.
And if this is making you go back and update your informed consent for some old clients to get back into compliance, that's a reasonable action right now. But making sure that your informed consent is not being seen as something that puts undue force onto a client. A big part of consent into healthcare is knowing what is going to happen, knowing that it's predictable, that it's enforceable. And again, listen to our other episodes on good informed consent procedures here. But what ends up happening is that, as Richard Leslie points out, is depending upon the facts and circumstances of a particular situation, a licensing board conducting an investigation upon a complaint by a patient who signed such a form that the licensee's actions in, quote, requiring the signing of such an agreement as a condition of treatment constitutes a violation of one or more laws, regulations, or ethical principles. What this article goes on to talk about, in particular around therapists who are either scared to death of going to court, don't want to be involved with it at all. This article points out that you can't just make people agree that you get to skip your legal responsibilities.
Yes.
This is akin to having people sign paperwork with you that says, I don't ever have to do jury duty. And
Or if I kill you, I'm not liable.
I don't know that I would ever put that one in writing, but there are a number of places of the law that specifically spell out what a healthcare provider's responsibilities are, including confidentiality and privilege. And in fact, it's such an important piece that most of the laws around this are times when you either can or have to breach it, which is a legal requirement. And so I get it. Nobody really wants to go to court. Nobody wants their day disrupted. You have to dress up, you have to go and potentially sit around for a very long time. You're missing out in doing anything more interesting and fun, or missing
lucrative.
seeing your other clients. And unless you're somebody who really wants to be involved in like expert witness testimony kinds of stuff, that you don't want to be doing this. So many people who have these clauses, I hear some sort of justification around, I just want to make it to where it's difficult. I want to give people, particularly in family courts, divorcing families, that I'm not going to go in and have to have my day ruined. And therefore, if I can just get everyone to agree from the very beginning that I don't have to go, then I won't have to go.
I understand why people would want to try to do that, but it's not realistic. There's going to be some attorney or some family member or somebody that says, you know, who would be great at weighing in on this? It's the therapist, right? And they can subpoena you. They can have a court order. There's all these things that they can do. And I think we actually have an episode with Nicole Stoller-Peterson about what you can do, what you need to do, and also what are the things that you can't do. You can't move from, as a therapist, being a fact witness to being a witness, an expert witness. Like, you can't do both things. So if you're going to go to court, this isn't the episode for you. We've got that somewhere else. We'll put it in the show notes at mtsgpodcast.com. But in your consent, I think it needs to be very clear. You can't say you're not going to court. That's just not possible. Nobody can refuse to go to court indefinitely for all different reasons.
And as Nicole points out, that's a really fun way to find out at a traffic stop or violation some point down the road that, oh, you have a bench warrant out for you, and
Oh,
you
I forgot about
for
that.
skipping going to court. So
Yeah.
these kinds of informed consents sound almost like sovereign citizens who don't have their driver's license or their license plates, paid up. They refuse to talk to government officials because they have some sort of interpretation of the Constitution that makes it to where logic doesn't apply.
I just do what I want.
Not only does Therapy Notes combine the basic tools you need to succeed in your practice, but they also offer an ever-growing library of outcome measures, custom forms, secure messaging, and more. And with their always available live customer support 24 hours a day, 7 days a week, help is just a phone call or email away. Try it for 2 free months today using promo code MODERN. Now, to expand upon this, if we haven't already driven home the point that you can't just have this in your informed consent, some of the discussions that I've seen online in some of the therapist communities, sometimes in some of the law and ethics workshops that I give, even from some of my friends who are really, really trying to avoid these situations as well, is, well, I will just put in my informed consent that my court fees are astronomically high.
Yeah, like 5, 6, 7 times my normal fee.
Exactly. I want to scare people out of this. I have one colleague who was brought into court a number of times by the same family, was routinely underpaid for the situation.
Sure.
And this was fairly early in my career. And I asked, well, at least you're getting paid, right? And he said, I try to raise my fee so that way it, is something where I try to make it worthwhile my time. But sometimes really litigious families just have way more money and are more keen on spending it to prove their ex-spouse wrong. And no amount of money is worth the headache of having to do this over and over again.
Yeah.
This is also something where, as you're pointing out, and we'll point to Nicole's episode here again, that there are different kinds of witnesses. And depending on what kind of witness you are, can really impact what kinds of fees that you end up being able to be paid. And trying to be a treating expert witness, that's at least in California law language, what a treating healthcare provider would be. Sounds like an expert witness. It is a kind of expert witness, but legal language in California says usual and customary fees to be paid for witness testimony and preparation. So if your fee is, let's say, $200 per session, and you put into your informed consent, if you take me to court, my court fee is $800 per hour, you can expect that the judge to say,
Nope.
Exactly. Hey, we've got your website pulled up right here. It says your normal fee is $200 per hour. That's what you're getting paid.
Yeah. And I think you can, from what I understand from the conversations we've had with Nicole, you can say you're going to pay me for my full day if you're sending me to court, but that would be, $1,800, $2,000 rather than $15,000 for a day at court. Like you can't push past the usual and customary.
You can't just bait clients into taking you to court so that way you get paid for a full day for 1 hour of work. But I sometimes see the justification in this argument. Well, I at least want to make clients pause before they take me to court. I get the sentiment. I validate the
Sure.
sentiment. This is also something where if it's your legally defined duty to do so,
Yeah.
you're not setting up necessarily the best, most trusting relationship with clients from the beginning. Hey, we haven't started working yet, but I mistrust you enough in these future situations that I'm going to try and milk you for every dime that you're worth.
For sure. And I think the bigger piece is it's clinical material. right? Whether they're going to court, there's so much there. And so to have this huge piece that is for your own benefit, and we have some episodes on, whether something's in the best interest of the client, so we'll put that over the show notes as well. But if it's not discussed, if it's not put into the clinical work, you're missing a lot. If someone is in a situation where they need you to go to court to help them resolve the situation or get something sorted out, and you're refusing, that's in the relationship. And it potentially, as Richard Leslie has said all through this article, unethical, illegal, harmful, those types of things. And so when I get a client that is either already in litigation or is in a situation that could become that, I talk about the kind of the cost benefit analysis and how we might work and what the things are. Like it needs to be part of the conversation so that you can actually do what you're supposed to do. And if you're hiding behind, well, I never go to court or whatever, or if you're just refusing all clients who may have litigation at some point, that may be bias. It could be discrimination. We've got episodes on that. Those will go over in the show notes as well. But it's something where life is messy, and being able to join our clients there and helping them with what we are required to do, I think is really important.
There's also what you end up doing at the court that might determine what kind of witness you are and whether or not you're even entitled to some of these fees in the first place. So if, for example, you get called to a deposition to read your clinical notes, you're not in the treating expert witness territory. And
You're a fact witness.
You're what's called a percipient witness. And those fees are actually spelled out in statutes in California. And for that, you get paid $35 per day plus travel expenses.
Oh my goodness.
So you need to also know what kind of witness you are, because this also sets your expectations clearly. And we'll point to an article in the show notes. This is by Anne Tranleen over at Kampft, who has a little bit more writing on this. But I want to dive into some of the other things that we've seen.
We've well covered the court stuff.
Yes. So I reached out to some of my therapist friends who are also in the law and ethics space and did a little bit of a poll around what are some things that you hear that are in people's informed consents. And collectively, we came up with some of the following, and we'll do a little back and forth on this. This one starts pretty good and then ends pretty terribly. I reserve the right to adjust fees at any time with or without notice.
So I hate to tell you, but my expenses have grown. And so today, instead of charging $100, it's going to be $300.
Yes.
Oh, that's not legal. There's all of the No Surprises Act. But I think there's also, it's bad business. The person's going to be pretty pissed. I came in with $100. You're telling me I have more to give you? Oh my gosh.
Yeah, I think this one, now that you say the No Surprises Act, hopefully has taken care of that one quite a bit. I don't think that we need to do a lot of back and forth on this. This one came up from our friends over at the sadly ended Very Bad Therapy podcast, but there was a therapist on there who had told someone, you're not considered a client until we've been working together for 30 days.
That seems like a really just random amount of time. Is that 30 days is the assessment and I am not your therapist while I'm assessing you? Like, what are the possibilities as far as rationale for you're not my client for the first 30 days I am treating you?
I'm going to make the attempt to see the good intentions of something like this.
Okay.
But seeing if an actual therapeutic working alliance can be developed without necessarily having the responsibility for actually needing to do documentation paperwork, have responsibilities over someone.
I don't know if that's, I mean, I can
I'm
see
making
that
attempts for somebody's bad logic here. So
well, I can see that 30 days we're going to get to know each other and then we'll lock in. Like I can see that, but not doing the paperwork, not committing to be your therapist for 30 days, it just feels weird.
seems like somebody who's maybe also protecting themselves from working with severe mental illness or diagnostics that might show up that might be more work than what a therapist would want. And to give them an out to be able to say, you know what, I'm not feeling this because you're above my pay grade.
Oh, yeah.
And that can be incredibly traumatic for clients on that end, but it's also just dumb.
When you hire Buying Time, you get an entire team of accountable, knowledgeable virtual assistants with different specialties. It's a pretty amazing one-stop shop for your business needs. And I should know, I've been a happy customer of Buying Time since 2015. Buying Time has helped me and other therapists with admin and client customer service, finances and bookkeeping, including sending out invoices and super bills, setting up automated systems to take care of clients during onboarding, marketing, websites, social media, blogs, newsletters, and a whole lot more.
Buying Time believes in streamlining efficiency and being cost effective, so they help you to regularly evaluate systems to make sure you're not paying for programs and platforms you don't need. And they put together a free systems inventory checklist to help all of us to uncover hidden expenses and optimize spending in your practice. Go to buyingtimellc.com/MTSG to get your free checklist now.
I think it seems to be trying to avoid the challenge of not abandoning a client.
It does.
So we're even from the first phone call, we have an episode on this too. I'll try to find it because I don't remember what we called it. But when we have to refer someone out or they initially call us, like there is a responsibility that we have.
Yeah, and there's another article from CPH that we'll link in our show notes that talks about when does your responsibility to a client actually become a client? If
Yeah.
some person reaches out to you from a therapist directory, they find you, they leave a voicemail to you, you're not responsible for them yet. I don't know if that would, start some 30-day clock as far as when you might end up being responsible. But it's once you agree to services, that's when they become your client.
Yeah.
And it's your responsibility to do a proper intake, to be able to know whether or not you're going to be able to help someone. And that's what your screening processes are for. That's what a thorough assessment is about. That's what ongoing consent is about, is being able to work together in a way that, all right, we've hit day 31. Now we can develop that treatment plan.
When we're in a situation where we're trying to assess, is this client a good match for us? What do they need? Those types of things. We are still responsible for them. And I don't think it's a bad idea to comment that either the therapist or the client can say, hey, this isn't working for me. It doesn't take away the responsibility of the therapist, but saying that you're not my client for 30 days feels unsettling and doesn't allow for this development of a process, and then it doesn't actually protect you from letting the client go. So I think there's a clinical conversation about we're going to assess each other for the first 30 days, but legally and ethically, you're their therapist once you start seeing them.
Yes. All right, next one. This one comes from our good friend, Dr. Ben Caldwell, and we'll link to his blog to talk about this in more depth on this. But having package pricing or prepayment discounts, give me a bunch of money up front and we'll knock off 10% per session. Or if you agree to do 10 sessions, then it's $50 off per session. But if you only do 9, then it's my usual and customary rate. Here's your punch card for a discount. In Ben's article, he talks about that this could, at worst, end up putting you into akin to an insurance company because you're offering a package pricing for a commitment to a number of sessions.
Yeah.
It's something that I imagine most people will read and say, Ben, I don't agree with you. I'm going to do this anyway. And then potentially find themselves in extremely hot water when they become the poster child of the case that ends up getting put out for this, because we don't offer prepayments, discounts. That's becoming almost a creditor, or making it to where if clients end up terminating earlier, not needing enough sessions, that to meet the full discount price, that it puts you into a really awkward position of having to give clients money back or hold them to having to do more sessions to keep a discounted rate. It's just better to have a straightforward fee for service on every single session.
I agree with you. And I think that there's probably ways to make this somewhat doable. I think I know some colleagues that have found ways to make it fit through all of the hoops of making it work. For me, the fear I have with those types of things are just what you said, that there's a pressure to have clients do sessions that are not clinically necessary. And that becomes an ethical issue because you're forcing sessions that don't need to happen. So have clients pay per session. It's just easier.
I don't prepay my doctor to have my appendixes removed in bulk. Like, remove 3 appendixes, get the 4th one free. The same thing for therapy. And
Yeah.
well, it seems ridiculous, and hopefully someone out there is saying, therapy is different than the medical model. A lot of healthcare law doesn't really differentiate between the two unless it's specific to some of the business and professions codes kinds of things. So,
well, and also if you only get paid per session, it really helps for all the people who are trying to pull you into the scam where they have a family member that's going to be in your area for 10 weeks. And so what's your session fee? And I'll pay it up front. and oops, I accidentally paid something else. So can you refund me?
I even feel weird sometimes when a family will pay ahead for a session that's going to be happening later in the week. Usually this is around one of their kids or something like that, that I'll put your credit card on file and I'll charge it at the time of session as it says in our paperwork, but I don't want to be in the business of holding money and deducting it down. Next on the list is any attempts to have clients waive the therapist's legal liability.
Okay. Give me an example of that.
You agree to not sue me.
I mean, there's the mediation clauses that go into a lot of different contracts. Are we talking about that? Or are we saying just nothing? You can't do anything.
So there seems to be 2 versions of this. One is the you waive any right to sue me clause. And this is something that you'll see in marathon registration forms, or you'll see it in kind of large events kinds of things. The other is, as you're pointing out, mediation or arbitration clauses that rather than going to court, you will go through an arbitrator, you go through a mediator to be able to resolve this. More often than not, it seems like mediation tends to favor the professional in most of those situations, which is why a lot of businesses and healthcare providers would try to push someone to going to mediation. It tends to be more beneficial, whereas if something ends up in front of a jury trial of normal citizens who aren't either judges or other healthcare providers, that it becomes a lot more risky on determining what the outcome might be.
So are you suggesting that arbitration or mediation clauses are not in patients' or clients' best interest and they shouldn't sign them?
It's something that I'm not sure how enforceable it is.
Okay.
This is, again, magical thinking that we put into our informed consent. That is probably the title of the episode.
Magical thinking that we put into our informed consent. Okay, noted. I'll get right on that. But it seems to me that the therapists are trying to limit, again, their court involvement. And it's not necessarily illegal to put a arbitration clause in. It may be just, not worth it, not valuable to what you think it is. It's not doing what you think it's doing.
Yes. All right. I saved my last and favorite one.
All right. Here we go.
If you are traveling out of state, you agree that any services that I provide while you are traveling are considered coaching and not therapy.
Somebody actually put that in writing?
Yes. And I'm sure that there's more than one somebody.
Oh my goodness. I don't even know how to respond to that. That's so blatantly illegal. Like, this is the thing that we're talking about, that if a client signs it, they are signing something that's illegal, right?
Yes. You travel across this jurisdictional boundary, and it's some sort of portal to change the language of what we're doing. And you're just going to pre-agree to this ahead of time, that once you're on the other side,
to the dual relationship, to me breaking the law, you're going to agree to all those things, so I'm safe.
Which also brings the question, is what you're doing actually coaching when they are in the States? Because if it's not fundamentally different, there's some pretty big differences between therapy and coaching.
Yeah.
But making people agree to this, that, hey, if you're traveling, I don't want to do the extra work of trying to get, very time limited practicing privileges in another state. I don't want to have to refer you out. I'm just going to write down that it's coaching.
And do that as a blanket policy, not actually look at what are my clients' needs in this other jurisdiction.
Yes.
We're just gonna keep going as we're going, but it's gonna be called coaching. So I'm above the law.
It absolves me of any having to know what laws are in the other states as well.
Yes. Yeah. I just, listening to all of these, it just blows my mind, because I understand, for the most part, the rationale behind putting these things in an informed consent. But I really like that title for the episode. It's magical thinking. It's not this get out of jail free card. It really isn't.
I think more than ever, I want people to join our Facebook group, the Modern Therapist group. And maybe we create a sticky, like,
pin a post.
Pin a post that is, what are some of the other magical thinking informed consent language that you've seen? Because I think that this would be a fascinating opportunity for the community to build on the conversation for this episode.
Oh, for sure. We'll have to do that.
So join the Facebook group, the Modern Therapist group, and follow us on our social media. Check out the show notes over at mtsgpodcast.com. And until next time, I'm Curt Widhelm with Katie Bernoy.
A big thanks again to our partner, Therapy Notes, helping clinicians everywhere care more and worry less. Check them out at therapynotes.com, and don't forget that using promo code MODERN gets you 2 free months.
Buying Time is a full-service virtual support agency that is standing by to support you in your practice. It's time for you to get out of the day-to-day and bring in someone you can trust that has the experience to help you with all your business needs.
And don't forget to go to buyingtimellc.com/MTSG for your free systems inventory checklist. Get on the path to less expenses and more profit.
Thank you for listening to the Modern Therapist Survival Guide. Learn more about who we are and what we do at mtsgpodcast.com. You can also join us on Facebook and Twitter. And please don't forget to subscribe so you don't miss any of our episodes.